I call the meeting to order. Bienvenue à nos réunions. It's meeting number 123 of the House of Commons of the Standing Committee on Justice and Human Rights. Pursuant to order adopted by the House on November 19, 2024, the committee is meeting in public to begin its study of Bill S-13, an act to amend the Interpretation Act and to make related amendments to other acts. Just a few housekeeping rules I would remind members and witnesses to wait until you're recognized before you speak, and then all questions and responses are to go through the chair. I now would like to welcome le ministre de la Justice et procureur général du Canada, Monsieur Arif Virani. Monsieur le ministre, bienvenue au nos comités. Avec lui, we have Madame Laurie Sargent, Assistant Deputy Minister, Indigenous Rights and Relations Portfolio.
I have no interpretation. I thought it was just my device. I checked again. I'm currently on English.
Let's wait a moment and get that rectified. Thank you.
You too, James? Yeah.
This is the English interpreter. Can anyone hear me? So it's working.
Is it English or French?
When you were speaking French, it wasn't being translated.
Okay. Do you have it when I speak English, Monsieur Fortin?
Vous m'entendez?
Interpretation qu'on a.
Oui, mais je compte sur vous pour parler en français. C'est peut-être une bonne chose que mon collègue, Monsieur Brock.
Maybe I should be speaking French. Maybe it's a good thing that Mr. Brock, my colleague, is not getting interpretation.
No, I think you
I think he
smiled. So I think interpretations are working now. Je pense que qu'on peut continuer. Est-ce que c'est
I think we can continue now.
Would like to welcome from new the Minister of Justice and Attorney General of Canada, Mr. Arif Virani. Welcome to our committee, and also with him is Madame Laurie Sargent, Assistant Deputy Minister, Indigenous Rights and Relations Portfolio, et aussi Madame Ousma Insonalla, Directrice Générale et Avocate Générale.
General Director and Senior Counsel, Center of Indigenous Law.
There, and I do believe that okay, no, that's fine. Those are the three that I see there. So that's great. So, Minister, you have the floor now, and I, without any more delay, the floor is yours, and you have up to 5 minutes. Thank you. Oh, 10 minutes, I'm told. 10 minutes. I don't want to shortchange you. Thank you.
Madam Chair. Good afternoon, everyone. I'm pleased to be back here at the Justice Committee to speak about Bill S-13, an act to amend the Interpretation Act and make related amendments to other acts. Bill S-13 is a long time coming, colleagues. Indigenous peoples have been the driving force behind this bill for decades. I want to acknowledge in the room behind me we have members of ITK who are some of the principal movers of the bill, among others. I want to acknowledge their hard work, advocacy, and dedication in advancing this important legislation. I also want to thank all members of the House for putting aside the gridlock to allow this important piece of legislation to pass. Many First Nations, Inuit, and Métis have long called for Section 35-related non-derogation clause to be added to the Federal Interpretation Act. This clause would be standardized and signify the importance of upholding Aboriginal and treaty rights in Canadian law, as affirmed in Section 35 of the Constitution Act 1982, and would apply to all federal laws. Dans le cadre du plan d'action de la loi sur la déclaration.
In the UNDA Action Plan, released on June 21st, 2023, Indigenous peoples identified that the plan to adopt a non-derogation provision continues to be a priority. The adoption of this bill would mark the successful implementation of a part of the measures set out in the Shared Priorities chapter of the Action Plan. Consultations were held with several Indigenous partners who worked with us to advance this bill. Indigenous peoples and the organizations that represent them took part in more than 70 meetings and submitted more than 45 briefs concerning the legislative initiative on the non-derogation clause. I'm extremely grateful to everyone who shared their perspectives and technical expertise.
This brings us now to the substance of this bill. Bill S13's purpose is to add a Section 35 related non-derogation clause to the Federal Interpretation Act and to repeal most currently existing Section 35 related non-derogation clauses found in other statutes. In this context, a non-derogation clause is a clause that states laws should be interpreted to uphold and not diminish the Aboriginal and treaty rights affirmed in Section 35 of the Constitution Act 1982. Section 35 rights are of fundamental importance to Indigenous peoples. These rights are constitutionally protected from infringement by government action, including through legislation, unless infringement is justifiable in accordance with the rigorous test set out by the Supreme Court in Sparrow. At its core, Section 35 serves to recognize Indigenous peoples' pre-existing rights and systems of governance, as well as to recognize the rights from treaties that have been concluded between Canada and Indigenous peoples over the past centuries. A Section 35 related non-derogation clause aims to affirm and uphold this constitutional protection, highlighting the importance of applying federal legislation in a way that avoids infringing on these rights. Le projet de loi S13 ferait
Bill S13 would ensure that all federal laws are interpreted in a manner consistent with Section 35 of the Constitution. It would therefore no longer be necessary in the future to add a non-derogation provision to each federal statute. Thus, Bill S13 would also eliminate the burden on Indigenous peoples to advocate for a non-derogation provision to be added to each new bill that they believe could infringe on the rights recognized by Section 35. It should be by default that the rights of Indigenous peoples in Canada are respected. This fact should not have to be repeated in every law, regulation, and decree. S13 makes this possible. This bill, therefore, also contributes to the government's reconciliation efforts with Indigenous peoples. In addition, the bill promotes the uniformity of federal laws on non-derogation provisions. Over the past 40 years, an ad hoc approach, combined with the evolving legal landscape and law drafting practices, has led to non-derogation provisions that differ from each other.
federal statutes that contain non-derogation clauses with inconsistent wording. In order to ensure the clarity and consistency of laws, this bill proposes that almost all non-derogation clauses in existing laws would be repealed. The only exceptions would be a small number of laws where Indigenous peoples who are directly impacted by specific legislation have indicated that it is important to retain the non-derogation clause in question. I would underscore that the bill also builds on the important work done by the Senate Committee on Legal and Constitutional Affairs, culminating in its 2007 report entitled, quote, Taking Section 35 Rights Seriously, Non-Derogation Clauses Relating to Aboriginal Rights, end quote. Many Indigenous leaders and experts participated in the Senate committee hearings leading to the 2007 report, and Indigenous peoples continued to advocate for a non-derogation clause after the release of that Senate report back in 2007. In response to this ongoing advocacy and leadership, my department launched the consultation and cooperation process that led to the bill that is before all of you today. This started with preliminary conversations with key Indigenous partners who had been involved with the Senate report. Then in December 2020, letters were sent to nearly 60 Indigenous rights holders and representative organizations inviting them to meet with justice officials or to provide written submissions, which occurred over the following year. De décembre 2021 à mai 2020.
From December 2021 to May 2023, a significantly expanded group of Indigenous partners had the opportunity to provide feedback on the initiative. These new consultation and collaboration processes took place in 2 additional phases. The first of these 2 phases began in December 2021 when the previous Minister of Justice announced an expanded consultation and collaboration process in accordance with the requirements of the UN Declaration Act. Starting in February 2022, additional meetings took place with Indigenous partners, and several provided written responses in order to examine options for amending the Interpretation Act to include a non-derogation clause.
From March 1st, 2023 to April 14th of the same year, the final phase of the consultation and cooperation process involved posting a draft legislative proposal on the Justice Canada website. This method enabled Indigenous partners to review and comment on the draft legislative proposal. The draft legislative proposal was used to inform the language of Bill S-13, which remained identical. Throughout the process, Indigenous partners were broadly supportive of the non-derogation clause amendment, although there were differing views regarding the specific wording of the clause. Some preferred the expression, quote, Indigenous peoples, while others preferred the expression, quote, Aboriginal and treaty rights, as it more closely reflects Section 35 of the Constitution Act 1982. The proposed language in this bill uses both of these expressions to reflect a compromise between the language options. The fate of the non-derogation clauses found in existing laws was also the subject of sustained discussions with Indigenous partners. Many Indigenous partners argue that non-derogation provisions should remain in laws that directly impact Indigenous peoples, if that is the wish of the affected peoples. Les modifications proposées dans le projet de loi sont le reflet.
The measures proposed in the bill reflect what we heard from Indigenous peoples during the consultation and collaboration process. These discussions made it possible to enrich and clarify the wording of the non-derogation clause. Bill S-13 and the process that got us here is another example of what can be accomplished when we work together. It marks an important step for respect of the rights of Indigenous peoples in Canada.
The federal government, we are very proud to be able to move forward with Bill S-13 as a further demonstration of our commitment to reconciliation and the recognition and implementation of Indigenous rights. As parliamentarians, I think we can all be proud of the work we're doing together to ensure that all federal laws are interpreted in a way that upholds Section 35 of the Constitution. This initiative will contribute to promoting, protecting, and affirming Indigenous rights at the federal level and bring greater coherence and consistency to the interpretation of all federal laws. At the same time, I would emphasize that it is Indigenous peoples who laid the foundation for this bill by maintaining their resolve to see this initiative come to fruition. In that way, Bill S-13 demonstrates the important lessons of working in partnership and collaboration with First Nations, Inuit, and Métis in order to build stronger nation-to-nation, Inuit Crown, and government-to-government relationships. Thank you very much, Madam Chair. Merci beaucoup.
Thank you, Minister. We will begin with our first round, and just for the committee members, it's been a while since we've actually undertook a study. At 30 seconds, I'll raise this 30-second slot, and when the time is up, I'll indicate that your time is up. 6 minutes each, and we will start with Mr. Brock, please.
Minister, last Friday night, as Canada's second largest city burned and was under siege.
Yes, Mr. Biddle?
On the issue of relevancy, I know Mr. Brock
Why don't you
was
let me ask the
outraged.
question?
Mr. Brock was outraged last week when we were here.
My God.
He said, and filibustered for an hour when there was a suggestion that we may ask questions of Mr. Viersen unrelated to the topic at hand. This is unrelated to
Not a point of
Bill
order.
S-13. Yes, relevancy is within the standing orders.
Okay.
This is within the standing orders. If Mr. Brock can keep to his questions to the legislation, I know he insisted that we do the same thing 2 weeks ago. Mr. Brock of
incredible,
2 weeks
Biddle.
ago would have been very upset at Mr. Brock today. So I'm hoping if he can keep his remarks focused pursuant to the standing orders.
Okay, so thank you for that, Mr. Biddle. Relevancy is definitely within the standing orders, but I don't think Mr. Brock has even had a chance to
Of course not. This
to
is
even
Biddle's game
start
plan.
with the, so I'm going to start you back at 6 minutes, Mr.
Thank you.
Brock.
Appreciate
and,
that, Chair.
And we'll let you continue. And I know you've been here as long as I have been here, and you're very well versed.
And it's the members' time.
So
Yes.
please proceed.
Thank you. Minister, last Friday night, as Canada's second largest city burned and was under siege by pro-Hamas terrorists rioting in the streets, damaging property, inciting their vile messaging of their extermination of the Jewish state, all the while your leader, Justin Trudeau, danced away at a Taylor Swift concert, sharing friendship bracelets with other fans. You, as Canada's chief legal officer, remained silent. Why, sir, did you develop, or why did you display a lack of leadership and courage in calling out this extreme anti-Semitic hate and violence?
So, Minister, please proceed. Yes.
Well, I reject that categorization, and I also reject what happened on Friday night in terms of its appropriateness. What happened on Friday night was a disgusting and appalling act of lawlessness and unlawful behavior by people who would seek to sow havoc and chaos on our
Canadians,
streets.
Minister, would have appreciated
and
you
I-
calling
and I
that out
referenced-
at the
if I
time,
could
but you
finish, Madam
remained
Chair?
silent.
Yeah,
I'll
yes.
move on to my second
And
question.
I referenced that in my response in
Sorry,
the House of
Minister,
Commons
this
today.
is my time. A few weeks ago, November the 11th, during a bail compliance check, Toronto police officers
Can you stop the watch for a sec? Mr. Biddle, yes?
Again, I think the time was given to Mr. Brock to bring it back to S13. He has not done that and now has moved into another question unrelated to the topic. I know Indigenous rights are very important to him, and he should move back to that topic, as Mr. Brock was insistent last week that we stick to the topic and Liberals stick to the topic. I'm curious why Conservatives don't hold themselves to the same standard.
I mean, relevancy is very much as the base of the issue. So I'm going to have Mr. Brock now. We will start the watch again. Mr. Brock, just
I'll
be
get to-
careful.
I'll get to relevancy.
Okay, just
Thank you.
please go ahead.
We support S13. A few weeks ago, November the 11th, during a bail compliance check, Toronto police officers found themselves, Madam Chair, this is becoming ridiculous, and this is a pattern that Mr. Biddle
Point of order.
continually does at these committee meetings.
Mr. Biddle?
Well, the pattern is its relevancy. This is legislation. Mr. Brock acknowledged that the
Let
standing order
me
is
ask
pursuant
the
to-
question,
Again,
Biddle.
it's Mr. Biddle, Mr. Brock. We show each other respect in this room. And again,
Like
he
you're
insisted,
you're just-
he insisted last week that we stick to the topic at hand, and he's not doing what he insisted that we do last week. So I hope that Mr. Brock of a week ago will comport himself in the same way that he insisted a week ago that we should comport ourselves.
Mr. Brock, I'm going to
Thank you.
ask you to proceed before
Toronto police officers found themselves in the middle of an active shootout between rival groups. 16 firearms were seized, all stolen and smuggled from the U.S. 23 people, including a young offender with 3 firearm prohibitions, was arrested. In response, the Toronto Police Association, the Police Association of Ontario, and the Ontario Provincial Police Association, representing 35,000 officers across the province, were calling on the government for immediate bail reform. This is the federal government. Their calls to action included tough-on-crime measures that ensure repeat violent offenders are kept in custody, imposing stricter penalties for bail violations, and shifting resources away from ineffective gun bans
point of order,
to
Madam
focus
Chair.
on combating illegal firearm
Point
smuggling.
of order, Madam Chair.
Yes.
This isn't the first time.
Member of Parliament Maloney?
Look, Mr. Brock is entitled to his time. There's 2 points. One, he understands the importance of being allowed to ask his questions, a point he's made now more than once. But it's also important that he allows the minister the opportunity to answer the question, which he didn't do on his first question. And now he's asked 2 questions that have absolutely nothing to do with the topic we're here to discuss. So I think it is incumbent on you, Madam Chair, to get Mr. Brock to stay within the realm of relevance. I know that Mr. Brock thinks relevance is subjective, but it's not. It's objective, and it's for you to determine whether his questions are appropriate or not. And both of these questions are inappropriate and then far outside the scope of what we're here today for.
It would be very helpful if Mr. Maloney allowed me to actually ask the question, which he interrupted halfway through. Madam Chair?
So, Mr. Brock, you've got 3 minutes. We've stopped the
By my
clock, by
count,
the
I've
way,
got-
each and
I
every
still
time.
have
A
4
point of
minutes.
order. No, 3 minutes and 29. And we've stopped it every time, but I'm gonna take a minute break, so just give me a break for a minute. A link to S13, the bill that we are studying, so the clock will go back now.
I intend on doing that with the 6 minutes that I have available. Chair, thank you. Time to start it?
Yes, please.
This isn't the first time the TPA has raised alarms, Minister. In the House today, you proudly stated we delivered bail reform. According to premiers of provinces and territories and presidents of police associations across this country, they unanimously claim that Bill C-48 is an abject failure. Instead of blaming provincially appointed judges and justices of the peace, when will you finally toughen up our bail regime to keep our communities safe?
Okay, I'm going to allow the minister to please respond to that, and if you wish to bring it back to what we're studying.
Well, I object that categorization, and I'll refer the member to 3 points. The first is that the work of the Toronto Police Services is heroic, and I applaud their courage. The second point I would make is that there are 700 less police officers in Toronto now than there were in 2015 when we first got elected, which is a problem for the municipality and a problem for the province. The third point I would make is that that same TPS letter actually referred to the penalties that are involved for things like gun smuggling and gun trafficking. In preparing for this appearance, I actually noted that in Bill, if I can finish.
No, thank you, Minister. This is
Point of
my
order,
time.
Madam Chair, if he's allowed to ask the question,
This is
the
my
minister's
time,
allowed to
Madam
answer.
Chair. He's answered the question. He said he had 3 points. I gave him the opportunity to raise those 3 points. This is
He
the
wasn't
member's
gonna- he
time.
wasn't finished the
I'm
third point,
reclaiming my time.
You're good?
Thank you.
Point.
Oh, he didn't finish his, please go ahead.
The TPS called for enhanced penalties for gun smuggling and gun trafficking. We enacted those penalties
Thank you, Minister.
and enhancements in
Moving
Bill
on.
C-21, which
Moving
that
on.
member
Thank
voted
you,
against.
Minister. This is my time.
Thank you.
Thank you, Minister.
Yeah, I will. We know that Indigenous people are more likely to be victims of crime. This has been reiterated in numerous government studies, such as the MMIWG and the TRC, and the statistics don't seem to have changed much since these reports were made public. In 2022, StatsCan reported that nearly two-thirds, 62%, of Indigenous people have experienced at least one sexual or physical assault after the age of 15. Will you, Minister, commit to reinforcing the Canadian Victim Bill of Rights to better protect Indigenous victims of crime and uphold the United Nations Declaration on the Rights of Indigenous People Act?
Minister?
I absolutely commit to ensuring that people are protected from things like sexual assault, including Indigenous, and I applaud the member opposite for noting that
Enforce the
Indigenous
Victim Bill
people
of
are
Rights.
both Indigenous people are both overrepresented as both
Will you
accused and as
reinforce the
victims
Canadian
in our
Victim
system.
Bill of
Madam
Rights?
Chair, if I could finish my response,
Yes,
please.
please, Minister. Yeah.
So, and I applaud the notification and the recognition that Indigenous people are overrepresented in our system, both as
Will
accused
you
and as victims.
reinforce the Victim Bill of Rights, Minister? It's a simple question, yes or no?
View of the
The
Canadian
answer is
Victim
no.
Bill
Thank
of
you.
Rights.
Would the Minister consider a
Madam-
similar
Madam
approach
Chair,
to
Madam
victims'
Chair, point
rights?
of order. Point
We
of
have
order.
30 seconds left.
Finish my response, Madam Chair.
29 seconds now.
Well,
but
Madam Chair-
I hear a number of
Madam
points
Chair,
of order.
Madam Chair, if I could raise an issue, please. Generally, when we pose a
You can't make
question.
a point of order in your own time, Madam
Actually,
Chair.
I was at
No,
another
Madam-
committee and they
Madam
made
Chair.
that very clear. It's true.
Generally, you afford a witness the same amount of time it takes for the question to be put.
That's not being done. That's
is
my,
not being
that's my
done
fault here. You're taking a lot more time to ask, and you're
Well, the
not
reason I'm
allowing
taking
the
a lot
minister.
more time to ask
you're
is
not
that the
allowing
Liberal
the
members
minister
are
the time
constantly
to respond.
interrupting. I constantly have to go back to the original question, repeat myself. That's what's happening here.
So,
I can do it in 10 seconds, Madam Chair.
listen, we had stopped the clock. I'm not going to keep stopping the clock. We stopped it at 29. Can we please continue with that now?
I'm moving on to another question.
The minister
Before
said he
you do,
hasn't finished
Minister,
answering
have
the
you
question.
responded to that last question?
Madam Chair, we put on reverse bonuses for bail for intimate partner violence, which assists Indigenous women. That
Thank
was
you.
Bill
The answer is
C-75
no.
and Bill C-48.
Would the minister consider a similar approach to victims' rights as being proposed in this bill? Specifically, will the minister reinforce the primacy clause in the Canadian Victim Bill of Rights to ensure the rights of victims are considered, upheld, and supported by courts and other criminal justice professionals in every interaction with the criminal justice system? Yes or no?
Okay, Mr. Brock, your time is up, but I am going to allow equal time for the minister to respond as that last question, which was about 23 seconds.
Review that happened, I believe, at this committee 2 years ago of the Canadian Victims Bill of Rights. There was a lot of healthy and proposals that were suggested at that point, and we are always looking to ensure that victims' voices are empowered and that their rights are given primacy in our system.
Thank you, Minister. That didn't take that long, so we appreciate that. So now we will go to Madame Brière, s'il vous plaît, pour 6 minutes.
Merci, Madame la Présidente, et bienvenue.
Thank you, Madam Chair, and welcome, Minister, to the Justice Committee. Thank you for granting us this hour of your time. I'm going to be asking questions related to Bill S13. Why did we use the non-derogation clauses on a one-by-one basis, on a one-off basis? So one law at a time. I wanted to say that in terms of my first response to Mr. Brock, that I'm dealing with the issue of anti-Semitism in Montreal very seriously. I gave my remarks in the House, and I repeat what I said. I say that what we've seen in Montreal is totally unacceptable. In terms of your question, I want to say that in the last 40 years, we had to work one act at a time to repeat the language or find a compromise to the text used to show that there would not be any derogation from Indigenous rights that are protected under the Canadian Constitution. What's changing with this bill, S13, is that we have made an amendment that cites the law on interpretation that will have a broader application for any law or statute that we have at the federal level. And will help us in terms of consistency with the text that is used, because we've seen over the past 40 years an inconsistency where the language used in one bill 15 years ago is not the same as we used in something that dates from 15 months ago. Thank you. And so S13 covers 26 existing laws. There are 3 that are not affected by S13. Why are those not affected? And also, we don't talk about the Indian Oil and Gas Act. Why is the Indian Oil and Gas Act not covered? So there are 2 aspects to my question. Why do we not cover 3 laws? I'll leave the last question for Laurie Sargent, but in terms of the first question, we carried out many consultations over more than 2 years with Indigenous communities and the right holders as such, and our main theme was the nothing about us without us principle. So when we heard the rights holders say that they wanted, in their own circumstances, always to keep their own non-derogation clause because it affected their rights and their treaties as such, we decided to leave their non-derogation clauses. Most people decided that this comprehensive clause is much better, and so in 3 very discrete and precise situations, we decided to leave them in place. Laurie? Thank you for the question. So the act in question, the Indian Oil and Gas Act, is a long-standing act, and the non-derogation clause provision is different than that. What's covered by our amendment. There's a whole history to it because that was not equivalent. It acknowledges acts that are different from Section 35 of the Constitution. We decided we'd leave it aside for now, but that law will at some point be revised. And the provision that would be adopted by S13 would be used for the interpretation of those rights in the future. Thank you. Minister, in your remarks, you said that this was an important step towards reconciliation and that we were working in the respect of Indigenous people. Could you tell us a bit more about this? So, for example, it's related to an aspect where the UNDRIP, we have a implementation plan for UNDRIP, and they imposed the duty to go ahead with this clause. It's on our list of tasks, but what it shows very clearly for all parties, because it was a unanimous motion in the House, that for any party, for us, it's important to always ensure that we will not derogate from Indigenous acts, Indigenous laws that protect Indigenous people, either the Constitution or what's been put into place over 200 years. So it's a bit symbolic, but it affects the interpretation of the law, because when a court reviews a situation, and it has to be seen whether the Indigenous people's rights will be abrogated and one where we can conserve the rights, the latter will be chosen, and we will interpret our own laws in the manner of the latter interpretation, which protects their rights. So it's extremely important for all Indigenous people, the First Nations, the Inuit, the Métis, that we consulted to create this amendment to further advance reconciliation. Thank you very much. Thank you, Ms. Brière. And now, Mr. Fortin, you have 6 minutes. Thank you very much, Chair. Good morning, or hello, Minister. Welcome to our committee. So, Minister, I've been reading S13, and if I could summarize it in a few sentences, it aims to ensure that all of the acts in effect respect treaties and ancestral rights that are included and recognized in Section 35 of the Constitutional Act of 1982. How does S13 add anything to what Section 35 already proposes? So that's a good question. What it adds is that it's eliminating the burden of proof on the Indigenous people every time we look at a bill, to have them insist that we have to include a non-derogation clause in that clause. So that burden is removed from them. Secondly, it gives force to the Constitution with this interpretation in all of our parliamentary acts, especially when there's judicial review, when there's a dispute and they're before a judge, and where they have to assess a bill. It's guided by this amendment of choosing the interpretation which protects the rights of Indigenous people. But, Minister, if I had to argue the respect of Indigenous communities, it seems to me that I would start with the Constitution. Maybe I'm mistaken. Correct me if I'm mistaken. But to my mind, the best construction of a right is that it be integrated into the Constitution. That means it supersedes any other right or legislative provision. So I have difficulty imagining how the amendment to the Interpretation Act will add to the protection that the Constitutional Act already confers. That's a good question, Mr. Fortin, but what I want to emphasize are two things. So you're absolutely right in terms of the Constitution is primordial in our democracy. And the second thing is that there are aspects where we touch things that are protected by Section 35 of the Constitution. For example, the Sparrow case, where there was a question, can we justify a derogation or not? And that's something specific. With this bill, what we're telling any judge in any part of the country is that when you're tasked with interpreting a statute, a federal statute, you always have to choose the interpretation that will protect the Indigenous rights that are related to Section 35. And that's not the case at the moment. That's why, over the past 40 years, we always had to put in place a non-derogation clause one at a time. That will remove that burden, and it will help judges. So Section 35, it's there. So I imagine it was adopted right at the beginning at 1876. Well, it's been there for a long time. I didn't look up the exact date. But I'm not certain that I really understand the usefulness of Bill S13. I'm speaking very frankly here. It seems to me that the protection afforded by Section 35 of the Constitutional Act of 1982 is more important. That being said, there are other places that raise certain questions. You're telling us, if I've understood clearly, that it will contribute to strengthening relationships with Indigenous communities, have reconciliation progress. I would like to understand you tell me how S13 will help the progress of reconciliation with Indigenous people. Was there a request for that? Did you have representatives of Indigenous communities who have said Section 35 of the Constitution is not enough? And were they speaking unanimously? Or I'd like you to talk about this. Yes, they were unanimous, except for the three groups I've just mentioned in my reply to Ms. Brier's questions. The second thing is that we consulted several rights holders groups, and they all asked for this. The third thing I'd like to emphasize is that it's to reassure them that their rights will be projected in terms of any federal bill. It will be interpreted in that context. And what I want to give you as a useful guide is in the context in BC, there was a dispute on the rights of a mining company, and the judge consulted the fact that there was an amendment in their own Interpretation Act at the provincial level in BC saying that Indigenous rights must always be protected, those that are enshrined in the Constitution and in treaties, and that influenced their decision. That's the Gitaxala case. I can give you the reference in jurisprudence. And so it's already something happening in that provincial court, and now it's being added at the federal level. Thank you very much. So now we have 6 minutes for Mr. McGregor.
Thank you very much, Madam Chair. Minister, welcome to the committee, and thank you for being here to discuss S13. For me, a large part of my riding's population is Indigenous. In fact, 2 out of the 3 names of my riding of Cowichan and Malahat Langford are anglicized names of First Nations. So anytime I'm here as a member of Parliament discussing anything to do with Indigenous rights, it's not just merely a national issue for me, but also it's very local. I have a lot of constituents who are very interested in any time that we're discussing this, either in the House of Commons or at committee. I wanted to ask you about, you and I have both been here since 2015. In the previous 43rd Parliament, we passed Bill C-15, the Federal United Nations Declaration on the Rights of Indigenous Peoples Act. As you know, my province of BC also has similar legislation as well. The province of British Columbia, however, they also have an Interpretation Act, and in their Interpretation Act, they make specific reference to their UNDRIP Act. But we don't see that in the current federal version of the Interpretation Act, nor do we see an amendment being made in S13. Now, the Senate report on this bill did make reference to the fact that this could be a pathway in the future. And, if you read C-15, which is now part of the Statutes of Canada, it does state in Section 5 that the Government of Canada must take all measures necessary to ensure that the laws of Canada are consistent with the Declaration. So, I can appreciate what this bill does. It of course, has our support. I think it's an important bit of federal house cleaning to make sure that we have consistency. But perhaps I could ask you, Minister, why not follow the example of the province of British Columbia, and why not have in our Federal Interpretation Act, maybe through S13 or through another measure in the future, a specific reference to that very important federal UN Declaration on the Rights of Indigenous Peoples Act?
Thank you for the question, Mr. McGregor. And what I'd say to you is that the key rationale for us came down to effectively the consultations that were undertaken. And as I mentioned in my opening remarks, there was about 2 years plus of consultation just on this very bill, which may seem like a lot for some people for what is a fairly short bill, what some might consider an administrative or housekeeping amendment. But it was really important to get it right and do right by the rights holders that we consulted with around the country. And on the issue of how do you reconcile UNDRIP with the non-derogation clause that was being proposed, we didn't have wide consultation on that piece. And we felt it would not be appropriate to go ahead with that without doing the necessary consultation. I would also underscore that there's a bit of an internal inconsistency as well, were we just to do an amendment sort of through the parliamentary process on that very issue. Because UNDRIP itself, under Section 5, and you're probably aware yourself, calls for consultation on any legislation that may impact upon Indigenous people's rights. So even pursuant to the UNDRIP document that we passed, the UN Declaration Act at the federal level, we would be, by necessity, to comply with that statute, have to do that consultation.
The UNDRIP Act that we did pass does call to make sure that the laws of Canada are consistent with the Declaration. So if we're trying to look for a way of making sure that Canada's laws are consistent with the Declaration, I think a starting point would actually be through the Interpretation Act. Now, I can appreciate that maybe S13, it's a little bit too late to put that in the current version of the bill, but do you see a possibility in the future of using the Interpretation Act to make sure that Canada's federal laws are consistent with the Declaration as is called for in the Act?
Yeah, the answer to that is absolutely I would. And what I've heard from Indigenous rights holders is that they are very willing to embark upon that kind of consultative exercise. But at this point, S13, as it's currently stipulated and articulated, is what we achieve consensus on, and that's what we're moving forward with. But on the go forward, looking to ensure whether further amendments may be necessary to the Interpretation Act to reconcile it with UNDRIP would make a lot of sense. I think that is work that we should actively pursue.
Thank you. And then maybe another question I have is, in the consultations that you have, I mean, I understand that there was a very clear majority of stakeholders were happy with the direction that this bill took. But could you provide this committee with a little bit more detail on the nature of the minority views? Were they really over the language selection in this amending S13, or were they a bit broader? I'd just like to be informed on the nature of those minority views.
Well, it was a minority of views. As I indicated, it was basically 3 different rights holders that indicated they wanted to preserve the language that was in their own non-derogation clauses. And that came out in the context of the consultations. The wide majority of all of the other interventions that we had right across First Nations and Métis was that they were comfortable with the language as proposed. But I'll ask Ms. Sargent to reflect on the nature of the three groups and what motivated their concerns.
Thanks for the question. I think, as the Minister said, there were 3 nations, including Shishal and a couple of others. They had implementation legislation already for self-government agreements or other key legislation. They had very valid reasons for retaining the non-derogation clauses there, and otherwise there was broad support for the proposed change. Thanks.
If I could just add, Madam Chair, the site for Monsieur Fortin is 2023 BCSC 1680. That's the Gitaxala case. Thanks.
Fabulous, right on time. Thank you. We now start with our second round with 5 minutes to Madame Ferreira, s'il vous plaît.
Thank you, Madam Chair. Minister, Indigenous women and girls are killed at a rate 6 times higher than non-Indigenous, and more than half of the cases involving non-Indigenous women and girls between 2009 and 2021 resulted in charges of first-degree murder. But when the victim was Indigenous, police laid or recommended that charge half as often. The less serious offences of second-degree murder and manslaughter were more common. In my community of Curve Lake, Selena Taylor was a beautiful, beautiful girl. She loved animals, and in the words of her sister, she will forever be missed and celebrated. Selena is now another Indigenous woman who didn't make it home after her intimate partner violently assaulted her. Rest in power, my love. That's her sister, Sage Castell. When he was arrested for attacking Taylor, Jordan Moran was out on bail for a separate 2019 attack. And when he was out on bail in the Selena Taylor case, he was arrested in January 2021 for the alleged assault on another woman in November of 2020. As a final sickening coda, Moran was sprung on bail again in February 2021, just 3 weeks before Taylor died. Over the years, he also did 10 months in the Slammer for assaulting a Good Samaritan who suffered life-changing facial injuries. Today in the House, your response to my colleague to diminish crime in this country was, you said, and I quote, "We delivered bail reform." What would you like to say to Selena Taylor's family about your bail reform that you've delivered?
Minister?
To Ms. Taylor's family, I would express deep sorrow and sympathy in terms of the fact that Selena is no longer with us. I think that's a horrific crime, and it's a tragedy that shouldn't be happening in our society. What I would also say is that we've been working very hard to try and address violence against women, particularly Indigenous women. That's why we launched the MMIWG inquiry, and that's why we've had the calls to justice that we're working to implement. Some of the bail matters that you mentioned have actually been dealt with in Bill C-75 and Bill C-48, where we implemented a reverse onus on bail for people that commit intimate partner violence, and we accentuated that in Bill C-48. But what I would say to you is that the same thing that I've been saying repeatedly to many different provincial actors is that what I want to know, and I'm sure you want to know as well, Ms. Ferreri, is that the circumstances upon which that individual being released on bail at least twice by your account, what were those circumstances? Did the Crown contest the bail? I would like to know that. And if the bail was granted above the Crown's objections, did they appeal the bail through what's called a bail review? Was bail denied because there was no detention facility ready to take that person? Because what Canadians need to understand is that
Thank you.
a
It's my
likelihood of
time.
reoffending,
I've given you lots of
a
time.
likelihood of reoffending is one
Usually
of the
the time is
basis
the
grounds
same,
for denying bail.
Madam Chair.
And
Thank
clearly
you.
that wasn't accurately applied.
So, you know, I see you wanting to try to talk over this, and it's just, it's beyond insulting what you just said. And, you know, you blame everyone else. You blame everyone else. We saw this with then Minister Marco Mendicino. It wasn't his fault, right, that Paul Bernardo was transferred in the dead of night. He's just the minister. Minister, this is ridiculous. You are the minister. To blame the provinces is just absurd. And your murdered and missing Indigenous women, you've been, you know, the AFN President Cindy Woodhouse has said, this failure is not acceptable to our people. You have failed everyone, and you don't take any accountability. You have no humility at all. This is a letter that I sent to you on December 5th, an email, almost a year ago, by Haley Schultz. You were asked directly, repeatedly. It has been brought up multiple times. Her son, Bradley Pogue, was murdered. You have never acknowledged this letter. It is a public letter. I have all of the correspondence. You have said to my colleague today that you are not going to enforce the Victim Bill of Rights. Please, show some humility. Please read Haley's letter. I will
Point
walk
of order,
it to
Madam
you
Chair.
right
He
now,
did
if
not.
you
That's
want,
not an accurate
Minister
reflection of what the
Varani.
minister said. If she's gonna repeat what the minister said, at least have the
Would you like
respect to
me to
be
read
accurate.
the email?
So did you have a question?
My
You've got
question
35
is,
seconds left.
Will you acknowledge Haley Schultz's letter in the murder of her son Bradley Pogue that I sent to you on December 5th? Will you read this if I walk it over to you, and will you acknowledge her?
So, Mr. Varani, you have time to respond.
So I'll make multiple responses. So the circumstances of the death of Bradley, Haley's son, are well known to me. I have your letter right in front of me, and I've read the letter, and I've read her handwritten note.
Why wouldn't you
What I
answer
can
her?
say to you is that I feel desperately sympathetic with her loss as a parent, as anyone would, in terms of the fact that her son is no longer with us. What I can also say to you, Ms. Ferreri, is that there are certain things that confine my role. That matter is actually...
Phone.
That
Can't pick up
matter
the phone,
is,
can you?
if I can finish, Madam
No,
Chair?
no, Ms. Ferrer, your time is up,
That-
but the minister will
That
have
matter
time to
is under
respond.
appeal right now, and when a matter is under appeal, it would be entirely inappropriate for the Attorney General of Canada to weigh into the matter because it would transgress certain lines
not
about
what your email
perceptions
says.
of influencing the
Not
process
what your email says.
and ensuring that the sub judice rule is always complied with.
Complete lie.
Do I feel sympathy for a woman who's lost her child? Absolutely, I do. If I could bring that child back, I would do everything in my power to do so. But there are certain rules that confine what I can and cannot do as Minister of Justice. With respect to your comments with respect to ensuring that the bail system is working, I would simply put it to you that in the context of sexual violence in particular, it is not just me that have decried what's going on in the court system, particularly in Ontario. It is also journalists who have said that we don't have enough courtroom resources, we don't have enough Crown prosecutors, we don't have enough dedication to addressing sexual assault in our system. I can amend the criminal code, but unless it is administered on the ground by provinces, including in Ontario, all of those changes are for naught. We're seeing charges that are being stayed or withdrawn because of delays in the process where the province of Ontario is not meeting the Jordan principles of timelines for trials, and that is rendering an injustice for those individuals. And what we need, including to address those matters, is more resources, which includes more crowns, more police, more courtroom resources, and more detention facilities for people that need to be deprived of bail. Thank you.
Thank you for that response. It was a serious question that was posed, and I think it warranted a serious response. So thank you for that. We'll now move to the final 2.5 minutes for Mr. McGregor, followed by 2.5. Sorry, Mr. Fortin. Mr. Fortin, 2.5. Oh, dear God. Okay, I'm looking at the time, and I guess it's taken quite a bit longer. So Mr. Biddle, you have 5 minutes, followed by Monsieur Fortin and Monsieur McGregor for 2.5, and then we will conclude, if that's okay with the minister and the support with him. So, Mr. Biddle, The floor is yours for 5 minutes.
Thank you very much, Madam Chair. And I was just wondering, give you some of my time if you'd like to respond. I know none of the questions from the Conservatives were related to the legislation in front of us. Is there anything you'd specifically like to respond to
Some of the questions
that you weren't given the chance to? Yes.
I would just like to point out that some of the members opposite are actually former Crown Attorneys, and it's Crown Attorneys themselves, including the President of the Ontario Crown Attorneys Association, that has lamented the lack of resources to address what's going on. And I'll just read a quote from Donna Kelway, who's the President of the Ontario Crown Attorneys Association, who said, "We need to be able to make sure that we have the resources to be able to get bails properly prepared and bail hearings taking place." She went on to say, in respect of a $29 million proposed investment in Ontario, that, quote, "It's wonderful when the police are getting resources so that they can investigate all of these crimes, make arrests, and bring us the charges. But it's completely wasted if they're able to do all of that and then we don't have the resources to prosecute them." What Donna Kelway is pointing out is exactly what I've been reiterating. Amendments of the criminal code at the federal level obviously are important, but implementation of those criminal code changes on the ground in the courtrooms across this country, including the province of Ontario, are vital.
Perhaps it's a good point. I know there's some members who are pretending that they haven't read the Constitution. I was wondering if you could remind people who may be watching where the administration of justice falls, at what level of government.
The administration of criminal justice in this country falls to the provinces under the old, what used to be called the BIA Act, what is now called the Constitutional Act of 1867. But also importantly, the Constitution outlines under Section 11 a presumption of innocence and the right for any accused person not to be denied reasonable bail without just cause.
Ask a couple of questions, if I can, on the legislation before us. And I was wondering, how does this bill affect future legislation?
Well, I think it's really important because it goes to a bit of what Monsieur Fortin was asking me about. It reduces the burden, which has been primarily borne by Indigenous leaders around this country, of continually, whether we're dealing with, you pick it, various types of issues that we legislate in the House of Commons, to continually insist upon adding a non-derogation clause to work with drafters on what the vocabulary should be used in the specific terms in the text of that. That duty will no longer attract because we will have an overriding provision in the Interpretation Act such that it obviates the need for inserting a non-derogation clause in a particular statute.
Why was the past ad hoc approach to non-derogation clauses unsustainable?
Well, one, because it was cumbersome, it was burdensome on the Indigenous leaders, but thirdly, because unfortunately, notwithstanding the great drafters we have in the city, we didn't always have consistency of language, and that lack of consistency has led to non-uniform interpretation, which is not useful for the predictability that we seek to aspire to in terms of running a legal system and a justice system.
Why are bills like S13 and C61 important for nation-to-nation, Inuit Crown, and government-to-government relationships with Indigenous peoples?
Well, I think that because it demonstrates quite clearly that if you roll up your sleeves and do the work, we can actually accomplish really important things. Again, this is a bit of a technical housekeeping bill, but it is so important in terms of what it represents. And it's taking those distinct groups at face value. When we work separately with First Nations, Inuit, and Métis, we are establishing all of the relationships you just mentioned. We are invigorating them, and that's why you have Indigenous leaders in this room right now, because they are celebrating what we are about to accomplish as a parliament.
Does S13 affect Indigenous language rights?
S13 empowers and ensures that Aboriginal rights, as safeguarded under the Constitution and as safeguarded under treaties, are given priority and not derogated from or not diminished. What it does is, I think, when you complement it with the work we've done in other respects, and I'll take some ownership of this because I worked on the Indigenous Languages Act when I was Parliamentary Secretary to the Minister of Heritage in our first Parliament, the 42nd Parliament. But I think in each of these instances, what you're seeing is that rights affirmations, emboldening people, passing legislation, coupling it with resources to embolden people to protect and preserve their culture and their language. And I think this only bodes well for that kind of cultural protection in terms of having this kind of non-derogation clause.
Does this bill increase legislative efficiency?
1,000% it does. It short circuits what had been a cumbersome situation where we had burdens placed on Indigenous leadership to suggest languages to us. It allows us to be much more efficient and much more nimble in terms of the passage of laws.
I think that's my time. Thank you, Minister.
Thank you very much, Mr. Biddle, and thank you for the relevancy of all the questions that were posed that were directly related to our study, which makes my job as chair much easier. So thank you. We will now go to Monsieur Fortin pour 2.5 minutes.
For 2.5 minutes, Mr. Fortin. Thank you, Chair. Minister, with all due respect, you didn't convince me earlier. I'm convinced about the importance of respecting the rights and in the treaties that are already in effect, and I think it's essential that we continue to respect those, the ancestral rights. But I still believe that that Section 35 of the Constitution Act already accomplished that. But I want to you referred me to a decision of the BC court, but that's a trial court, unless I'm mistaken. Has the Supreme Court already addressed this issue? Has it already commented that stating that we should adopt, the need to adopt something like S13? No, I don't think so. The Supreme Court has already considered Section 35 of the Constitution, but not in the context of providing a non-derogatory clause on interpretation. Has another appeal court indicated that something like S13 would be necessary?
Merci de la question. Je vous dirigerai vers la Cour d'appel du Québec dans le renvoi relativement à la loi sur les enfants Premières Nations Inuit Métis. Ce n'était pas la question de savoir si on devait adopter une loi telle que S13, mais plutôt c'est quoi l'importance de cette disposition qui était dans la loi fédérale, donc une disposition d'interprétation, juste pour dire que ça soulignait l'importance pour laquelle, comme le ministre avait expliqué, de bien faire attention à interpréter la loi en question de façon cohérente avec l'article 35.
Merci. Il me reste quelques secondes. Vous m'excuserez, Madame Sargent, je ne veux pas être impoli. Monsieur le ministre, est-ce qu'il y a d'autres références, d'autres sources de référence, par exemple des auteurs de doctrine reconnus sur la question autochtone qui auraient dit l'article 35 ne suffit pas, il faudrait adopter une loi telle que S13?
Je vais vous fournir, si vous voulez, pour le comité, effectivement, ce qu'on a entendu pendant nos consultations, mais c'est un grand dossier parce qu'on avait...
Mais je m'excuse, Monsieur le ministre, je ne veux pas vous bousculer, mais il me reste à peine 5 secondes. Mais des articles de doctrine, est-ce que des auteurs en droit reconnus ont déjà demandé à ce qu'une telle loi soit adoptée?
Oui. Le rapport du Sénat en 2007 qui ont abordé le sujet à profondeur.
Merci. Merci beaucoup. Alors, Mr. McGregor, final 2.5 minutes.
Thank you, Madam Chair. Minister, similar to Mr. Biddle, I also want to touch on the subject of Indigenous languages. In my riding of Cowichan Mahalat Langford on the east coast of Vancouver Island, it's largely Coast Salish, so the dominant language is Hulkaminam. There's certainly variations of that, and then on the west coast, I have a tiny bit of New Chalneth territory. I wanted to, I know a lot of the rights related to Indigenous languages and their protection and revitalization are confirmed by federal statute. And I know we have the Official Languages Act, but I'm just wondering if you could speak, first of all, if there was anything you wanted to add in your previous answer to Mr. Biddle, but also just on S13's broad scope. Do you have any thoughts on how it's going to specifically interact with some of the provisions in the Official Languages Act? I just know that in my communities, the preservation of Hulkaminam is very near and dear, and we only have a handful of truly fluent speakers, and there are some very serious efforts being made to share that language with the younger generation, and success we are having success, but there is going to be some assistance required in order to keep this language alive and well for future generations.
And let me say, Mr. McGregor, that we share your passion for ensuring that language in particular gets preserved, as do the rest of languages that were on the verge of extinction. prior to the passage of the Indigenous Languages Act. I think they're a little bit divorced, but what I would say to you is that insofar as the Indigenous Languages Act, Bill C-91, I believe at the time, C-91 or C-92 in the 42nd Parliament, is a freestanding entity. It's coupled with an official languages commissioner and robust resources investments we've already made. And in terms of the volition of our government to continue to replenish those resources and maintain that strong preservation and integrity of official languages, that volition is there. I think where this provision will help is that it will allow a reviewing court, if it comes to that, to look at what we've done with the Indigenous Languages Act and to interpret it in a manner that abides by, promotes Aboriginal and treaty rights. That would beg the question if a specific group in question had a treaty or had established an Aboriginal right. There's a legal test for that as well. But if that can be established in law, then the interpretation that would be given to upholding and promoting that language would be emboldened by this kind of amendment. So I think it works in the same direction in terms of advancing reconciliation, advancing Indigenous rights, including, given the particular case, Indigenous language rights.
So thank you very much, Minister. Thank you for appearing, and thank you to your support that is with you today. That concludes this particular segment of our meeting. We will adjourn for 5 minutes as we prepare for the in-camera steering committee only part. So I would request those that are on the steering committee to please stay. The rest, thank you very much, and we'll see you next time.